Sentencing the criminal offenders. Introduction. Since the sentence that is handed down specifies a particular punishment for the offense, the best place to begin our discussion of sentencing is with examination of the concept of punishment and the types of penalties for crime. Learning outcomes. After you have studied this study session, you should be able to 1. Define the concept of punishment. 2. Explain the justification and aims of punishment. 3. Highlight the goals of the criminal justice system. 1. The concept of punishment. Punishment is any action designed to deprive someone of things of value because of something the person is believed to have done. Barlow, 2000. Valued things include freedom, civil rights, money, health, identity, personal relationships, and life itself. According to Barlow, 2000, throughout the ages, rulers have devised all manners of punishments for people found guilty of wrongdoing. However, the more serious an offense was considered to be, the harsher the penalties attached to it. Many people consider the harshest penalties as those that cut offenders off from their families. For example, when a judge formally announces a sentence in a felony case, the penalty could be as little as 12 months on probation or as severe as life imprisonment or death penalty. Types of penalties for crimes. Having briefly discussed the concept of punishment for crime by Barlow, 2000, it is therefore pertinent to describe the three major types of punishment that criminals face according to Barlow, 2000. 1. Official criminal penalties. These are punishment by law and imposed by a jurisdiction according to legal procedures. For instance, in most countries like United States, the most commonly used official penalties for felony crimes have been imprisonment, fines, probation, and death penalty. 2. Extralegal penalties. These are best thought of as informal punishments. They are not illegal, neither are they specified in law as penalties for crime. Extralegal penalties may be imposed by all sorts of people, and they come in many forms. Examples are loss of friendship, rejection by family or community, divorce or refusal to marry, and various forms of harassment. Some of these may occur in the context of official criminal penalties. For example, when guards humiliate or insult prisoners, or are slow in responding to requests for assistance. Those actions are extralegal punishments, even though they occur in conjunction with official criminal punishment. Extra penalties are usually imposed in addition to official criminal penalties, and they may be imposed even when a defendant has been acquitted of a crime. 3. Illegal penalties. These are punishments that are against the law, such as torture or mutilation, or that applied illegally. 3. Illegal penalties. These are penalties that are against the law, such as torture or mutilation, or that are applied illegally, such as lynching of a convicted murderer or the use of excessive fines. It is not always clear whether a particular penalty is or is not illegal, and so appeal courts will sometimes be asked to decide. For example, a penalty may be appealed to the Supreme Court as a violation of the Eighth Amendment prohibition against cruel and unusual punishment. If the court agrees, that particular penalty becomes illegal for the offense charged. Justification and aims of punishment. There are two major arguments offered as justifications for the punishment of criminals. The first is called the justice model, and the second is the crime prevention model. Both models justify punishment in general as well as in its application to specific offenders. Let us look at the two models in detail. 1. Justice model of punishment. According to the justice model, punishment is justified 1. When people are guilty of willfully violating the laws of the society in which they claim membership, and 2. When the guilty person has received a punishment matching the gravity of the offense. The combination of guilt and making the punishment fit the crime is called proportionality, which makes a particular legal punishment a just desert. In order to achieve proportionality in the society, the following possibilities are suggested. They should be able to 1. Make the punishment mirror the crime itself. An eye for an eye. 2. Adjust the severity of penalties according to the social harm caused by different offenses. And 3. Link the penalty to the moral outrage felt by a majority of citizens. 2. Crime prevention model. Reductivism. The key to reductivism is the idea that punishment can prevent crime. This idea was borrowed from the philosophy of utilitarianism. For instance, utilitarians hold that the social value of something is found in its contribution to the greatest happiness of the greatest number. According to Beccaria, 1963, applying the utilitarian view holds that although crime may produce pleasure for the criminal, it produces pain for others. However, if punishment prevents crime, the group as a whole is given more pleasure at the expense of the criminal. An ideal punishment, in Beccaria's view, is one that is both proportionate to the offense and sufficient to outweigh the pleasure derived from it. So crime is prevented when people refrain from offending so as to avoid the pain of punishment. Goals of the criminal justice system. 3 overall goals unite the 3 functional areas of the criminal justice system. These include 1. Tracking down and punishing those found guilty of committing crimes. 2. Maintaining order. 3. Promoting justice. Barlow 2000 lists the immediate goals and primary activities of the police, the courts, and corrections, and found that one area relies on another. For example, a primary goal of the police is the detection and arrest of suspects. Unless that is accomplished, the courts have no one to process, and therefore cannot achieve their goals of determining guilt or innocence and promoting justice through fair punishment. Likewise, if no one is declared guilty by the courts, the goals of corrections cannot be achieved. Like any other system, the whole achieves its purpose only if the parts accomplish theirs. These interrelationships of subsystems of criminal justice system is shown in the list below. Barlow, 2000. Goals and primary activities of the criminal justice system. Overall goals of criminal justice system. 1. Track down and punish those guilty of committing crime. 2. Maintain order. 3. Promote justice. Goals of police. Primary goals. 1. Enforce the law. 2. Maintain order. 3. Prevent crime. Primary activities in support of the goals. 1. Detection and investigation of crimes. 2. Identification and arrest of suspects. 3. Routine patrol, surveillance, and intelligence gathering. 4. Education and training of officers and citizens, including children, e.g., bicycle safety. 5. Community and problem-oriented policing. 5. Community and problem-oriented policing. Goals of courts. Primary goals. 1. Determine guilt or innocence of suspects. 2. Set the appropriate penalty upon conviction. 3. Uphold the cause of justice, including due process. Primary activities in support of goals. 1. Prosecution and defense of suspects. 2. Pretrial hearings. 3. Impartial bench and jury trials. 4. Plea negotiations. 5. Sentencing. 6. Appeals of convictions or sentences. 6. Appeal of conviction or sentence. 7. Provide probation and parole services in conjunction with corrections. Goals of corrections. Primary goals. 1. Apply court-ordered punishment. 2. Maintain safety and security of correctional personnel and community. 3. Uphold due process and other constitutional rights of offenders. Primary activities in support of the goals. 1. Design, construct, and run prison and jail facilities. 2. Carry out the death penalty. 3. Design and implement correctional programs. 4. Provide probation and parole services in conjunction with courts. Study session summary. In this study session, we discussed the justification for and aims of punishment. We also noted the three main goals of criminal justice system. We explained how the police, the courts, and corrections address these goals separately and together. That ends study session 3. Thank you for listening.